Sounds good.
Okay, cool. Hello, good afternoon, everyone. So welcome to you all. Thank you all very much for joining us today. And we hope you enjoyed the session and it whets your appetite for studying property law.
What we're going to talk about today is the connection between property law and activism around the toppling of statues. Now, perhaps you think the issues are a million miles away from property law. They're about history, colonialism, and race. But what we're going to suggest today is that property law rules are at the heart of these campaigns. Perhaps it's the hidden heart of the campaigns, but the heart nonetheless.
So you're all going to be able to send comments on the chat, which only Helen and I will be able to read and respond to. And as the session goes on, we do hope that, that you'll get involved. We've got some questions that we'd like you to respond to. And we're going to be asking you for your thoughts on some of the things we're going to discuss. So coming back to the plan for the session, before we talk about statues, we're going to introduce you to the idea of ownership and suggest that ownership is more relative and less definitive than you might think. In English property law, possession is important, and so is another concept, relativity of title. Don't worry about this, we're going to tease it out through our discussion topics. So first of all, we need to introduce ourselves. I'm Ed Kirton-Darling. I'll be convening Foundations of Property, a module that those of you who are coming to Kent will study in the first year of your degree. I also convene homelessness law and policy, and I'm a former solicitor in practice and have experience of research in relation to homelessness and housing and those areas.
Great, and I'm Helen Carr. I'm a professor of law at Kent Law School. I was also a solicitor in practice, but a very long time ago, and I sit as a part-time judge looking at property disputes. I teach land law on the second year of the degree if you come to Kent, and if some of you are really keen on property law, you might decide to study advanced topics, and I lead that in the final year of your degree. Okay, now let's turn to exercise 1. There's some questions here to get you thinking about property. Now don't worry, because we're not asking you right or wrong questions, but just what do you think? Okay, so this exercise we call finders keepers. Okay, so I'll just read it out loud so you can digest the information as we go along. Just imagine you walked into a classroom, found on a table a very valuable watch. You pick it up and try it on. It looks rather good on your wrist and you decide to leave it on. Another student comes into the class and notices your watch and says, oh, that's very similar to a watch that I gave to my girlfriend. You're a bit embarrassed and don't say anything about having found the watch. Okay, so just think of that sort of scenario, and then here are the sort of questions we'd like you to think about. When an object is found, who owns it? Imagine that the watch was purposefully left in the classroom by the ex-girlfriend after she decided that she didn't want anything to do with her ex or any gifts that he'd given her. Who owns it now? Imagine that alternatively, the watch had been stolen from the ex-girlfriend when she took it off to go swimming and she's not seen it since. It transpires that it was sold by the thief to Becca, who left it by mistake in the classroom. Who owns it now? And then imagine that alternatively the watch was given by the ex-girlfriend to her friend Donna to keep it for her, and Donna lost the watch. Now, who owns it?
So let's go back a step and look at some of those first questions. And we're interested in people's thoughts on these questions. So we've got this watch, you found it, you've picked it up, and it looks good on your wrist and you're keeping it. You decide to keep it, finders keepers. An object's been found, who owns it? Be interested in your thoughts.
Is it English law, finders keepers? Is that the law? We all say it, but is it the law?
And we've got some answers coming in.
Great.
Some people suggesting that, oh wow, all sorts of communist music playing. Ex-girlfriend owning it. If you find something, the object still belongs to the person who lost it, the first owner. Lots of thoughts. So what about the question of it being left by the ex-girlfriend who's decided that she doesn't want anything to do with her ex? Does that change things? Yeah, a lot of really interesting contributions. So lots of people saying all sorts of different things. The range of people who might potentially own it.
Really interesting. Yeah.
All right. Shall we? Yeah, what still belongs because you can't guess that it's been left purposely. Okay, so let's look at this third scenario. So it's been sold, left by mistake, but we've got a thief in there as well. Does that change things? Yeah. So yeah, really interesting range. Do you want to summarise any of those, Helen?
Well, I mean, I think the interesting thing about this is that you could decide all sorts of reasons as a society as to who should get it in certain circumstances, and there's just been decisions made about what the law should be. So in English law, possession of an object raises a presumption of ownership. So in a way, that's where we get our idea of finders keepers, and that's the starting point. But that can be rebutted. So that can be overturned in a sense by showing that someone else holds title to the object, by which we mean they actually bought it in some quite formal way. So, for instance, if I lend my book to somebody else, I haven't transferred my title to the book, I've just lent it to them for a period of time. Whereas if I sell my book, I've clearly transferred title through the contract. Now, gifts are a bit more complicated. I need to have the intention to transfer title, but to complete the gift, I also need to transfer possession. So by either handing it over by delivery, we call that, or by deed, I could do a formal document which hands over possession. If I lose possession of my book through loss or theft, I haven't lost my title, I can recover possession. Now, Ed, do you want to say something more about losing things?
Yeah, absolutely. So possession is really critical. But the point is that this idea of possession can be rebutted. It can be displaced. And so in the case of lost objects, the presumption of possessive ownership, the idea that if you have possession, then it's yours, is displaced by proving that I am the person who owned the object before losing it. So you can displace that presumption. Even if someone else is now claiming it by having found it, I prove my better title by showing that my claim is stronger than theirs. And this introduces the idea of relativity of title, that two people can have a claim on something, but one person's claim can be stronger than another person's. And the question then is, who has the stronger claim? The issue with relativity of title is this question of who has the stronger claim for that property. My claim is stronger because I had title, did not give title away to anyone else, and my title predates any other claim. That's a particularly strong claim. So an important aspect of relativity is the time frame. It's sometimes the case that the time frame operates so as to allow others to assert title, to assert ownership, through the very fact that they have had possession over a period of time during which the person who we think is the original owner tried and failed to reclaim the object. So just having it in that time, even when someone else is trying to get it back, can give you the chance to gain a greater title. And this is really critical in land law, and there's going to be getting lots more into this in the course itself, or we will be if you come to Kent. But Helen, do you want to talk about force a little bit?
Yeah, just before that, I'd just say, so squatters' rights, you'll probably have heard of that. That's something to take away. And the other thing to take away from this is that it means that two people can each have a valid claim to something at the same time. Okay, so that's perfectly, sometimes landlord students find it difficult to get their heads around that, but two claims at the same time, but one will be stronger than the other. Anyway, turning to possession through force. What if you lose possession through force? And that's what makes the question of your title problematic, especially when this is political force. But then circumstances might change and you try and reassert your title. So you can think about this in terms of the expropriation of objects or goods during archaeological excavations, or perhaps through occupation. So, for instance, the Parthenon marbles, which were previously known as the Elgin marbles, or the expropriation of land during periods of colonization. So you know, the British come in, colonize the country, and then politics change, they leave, and land claims are made by the original people who lived there. And it could be through warfare as well. So art owned by Jewish families who had it confiscated by the Nazi government, and then they're defeated in the war. So what happens then? Now, these are really big questions, and law has responded in particular ways. And you'll get the opportunity, if you come to Kent, to think about all of this in the course of studying property. But the thing we can draw from this is that property law has moral dimensions. It's not just a reflection of common sense or the natural world, but reflects choices that are made over time. And also, ownership is not just about asserting your rights over something, for instance, being able to exclude people from your land or your property, but is also about your responsibilities towards others. So a lot going on there to think about, but that's the way that English law approaches possession and property.
Right. So what does all of this have to do with toppling statues? So we want to turn to the vital public discussions which are taking place at the moment, and specifically the question of the statues that have been in the news the last couple of weeks. But before we get into this, we want to say that at Kent Law School, we support the Black Lives Matter campaign, and our critical approach is focused on a critical approach to legal education and to the law, is focused on thinking about the structural and individual injustices that are part of society here and around the world, and the intersecting injustices caused by law's role in creating and resisting racial discrimination, as well as the ways this intersects with poverty, gender, and other characteristics. These are all central to our the way that we approach law at Kent Law School. So, thinking about ownership in particular, and some of the discussions that that we've been having in at the start of this session about ownership, and focusing in particular on the statue of Edward Colston, which was pulled down by protesters in Bristol this week, a couple of weeks ago, and dumped into the river. We wanted to ask what you thought property law might have to do with it. So take 30 seconds to think about it and send us your thoughts. And while you're thinking about it, for those of you who've not followed the news in the UK, because many of you involved may be international students, may not be following the news in the UK as closely, the story that we're focusing on relates to a man who died in 1721. Edward Colston had a leading role in the Royal African Company, which is estimated to have transported around 84,000 African men, women and children who've been traded as slaves in West Africa to the Caribbean and to the rest of the Americas, of whom 19,000 people died on that journey. In 1895, so many years after he died, a statue was put up in central Bristol to honour him, apparently for his charitable work and for his philanthropy. but it's long been contested in Bristol, the existence of this statue. And 2 weeks ago now, a group of protesters pulled the statue down from its plinth and tipped it into the River Avon. So we're interested in this question of what we think property law might have to do with it. And we've had some interesting responses there. Do you want to summarise some of those, Helen, or talk to some of those?
Let's have a look. Oh, that's interesting. That it might belong to the government. The Queen. The Queen owns all the land and the fixtures. Really interesting thoughts. Most of you seem to think that some way or another it belongs to the state, whether it's the Queen, national government, local government. Somebody has talked about it being gifted, and now that's a really interesting point, and that would actually take us into trusts, which we're not going to touch today, but very interesting point. Yeah.
And also,
somebody's mentioned the public. That's really interesting. Who are the public in this context?
And the question of it being protected by the state, not just necessarily owned by the state, but the protection can be separate from ownership. And other issues being raised around vandalism, around theft, questions of criminal nature. So let's take this on and try and take this further. And I'll share the slides again. So where are we? Okay.
Brilliant. Okay, right. So let's try and pin it down. As I say, the thoughts are really interesting. We heard the Home Secretary, Priti Patel, say that those involved in removing the Colston statue would face legal consequences. Now, the most likely consequences are from the criminal law. Charges of criminal damage. Now, if we look at the charge of criminal damage under Section 1 of the Criminal Damage Act 1971, let's see what it tells us about property. Okay, now, shall I read it out? Now, a person who without lawful excuse destroys or damages any property belonging to another, intending to destroy or damage any such property, or being reckless as to whether any such property would be destroyed or damaged, shall be guilty of an offence. So I think we can see the relevance of property law here, that it's the Criminal Damage Act is about protecting people's property from damage. Now, we've already talked a little about the difficulty of deciding who owns this statue, but the Criminal Damage Act, it's made a decision in statute as to who is to be treated as the owner. So what it says is that property is to be treated under this act as belonging to any person having custody or control of it, or having in it any proprietary right. Well, let's forget the bit about proprietary right, because that doesn't matter. But who do you think had custody or control of this property? Any thoughts?
And while you're thinking about that, I think it's worth saying, some of you, this may be the first time that you've been introduced directly to pieces of legislation, and a big part of being a lawyer is unpicking, and being a law student is unpicking the different parts of this legislation to try and understand the definitions of the words within it. So that's part of what we're trying to do here, to try and engage with this question of who belonging to another, what does it mean?
There's somebody interesting who says it belongs to the person who erected it. Well, that would be fine, but that's actually something really important to remember about property. One of the things that makes property law so unique is it lasts forever. So when was this statue put up? The people who erected it are long dead and gone. But I think it's accepted that here it's Bristol City Council that has the custody or control of it.
But look, Helen, you're focusing on the criminal responsibility of the protesters. That's your focus here on the Criminal Damage Act. not on the deeper question, I think the more important question of whether the statue should have been removed before these protests ever happened. What you were saying before was that owners have responsibilities too, and I think we should turn to talk about that question of responsibilities of owners.
Okay, yeah. So if we decide that Bristol City Council has some form of ownership of this because it's got care and control of it, what on earth does that mean? You know, who are the City Council? Who is democratically who controls the City Council? So they have, and also it's in a public place. So that also changes a bit the way we think about it. So as we said before, property law is just not about an owner having absolute control. That's only part of ownership. There is also the question of the responsibilities that owners have over property. So I think some of you have been talking about that and saying the statute should have gone long before. So that could be part of their responsibilities towards the public. So yes, somebody here has said there's responsibilities to the general public, the people of Bristol.
And someone else has commented that there were previously peaceful requests made to take the statue down prior to it being pulled down. So there's questions of democratic participation and engagement in trying to, in relation to these questions. So what relevance is it that it's in a public space? So what difference would it make if it was in the front garden of one of Colston's descendants? What do we think? Interested in whether this question of it being in a public square changes the relationship, the responsibilities.
Yes, so yes, that somebody has said, well, it would then belong to the people who owned the land it was on then, so that would change it a bit. But do they still, if it's in the front garden, do they still have responsibilities towards those people who may be offended by it?
Yeah, it's still visible in the front garden, it's still there and available for people to see. What difference does the land that it sits on make? And yeah, we've got people, all different kinds of thoughts being raised about whether it could be seen from the public space, whether it's on private property, and so that there's less that can be done. Private owners exercising freedom of expression, and so the less appropriate to act.
Then, yeah, and somebody else there has said, well, if it's on their land, it's up to them. But is that right? Is exclusive control of property by owners, is that an absolute right in these circumstances?
Someone said, is the statue offensive?
From what I understand from the listing, it's quite an artistic rendition, but of course it could be offensive because of what it omits from the plaque. So perhaps then the public should have a say in this. Is there an issue around whether it's a majority of the public? Do the majority have to have the final say, or a minority who perhaps find it particularly offensive? People have said peaceful enjoyment of their lives.
Yeah.
Yeah.
Really interesting, lots of really interesting contributions here.
Yeah.
So could the statue represent hate speech?
I think the problem there is it's the omission of information that people find particularly offensive, that it's...
and the existence, the celebration of someone who, you know, is so closely associated with slavery. So let's move to then think about the question of moving further on then. So what about if it was in the back garden? Does that change? Those of you who were talking about it being visible from the space and those sorts of things, does it change if it's in the back garden and it's not something that can be seen from, sorry, the helicopter outside, something that can be seen from the street or from public spaces?
Yeah. Somebody says the responsibilities are different then. Freedom of expression, very interesting. Yeah.
Private owners' right to freely express themselves. And then others still saying it makes no difference, that you know that it's that if it's offensive, then something should be done about it. So there's visibility is critical in this, the visibility in a public space.
Yeah. Yes, so that is really very interesting.
So what then if it was some of Colston's descendants wanted to pull the statue down, if it's back in the front garden, say, or in the back garden, some of his descendants wanted to pull the statue down and others didn't? How should that situation, how would you see that situation as changing this scenario?
So is this when it's still in the back garden, Ed?
It could be either the front garden or the back garden. I think that there's people can reflect on either. I mean, what impact does it have? And it could be that some of the descendants own the land that it's on. Should it be down to simply those people who own the land, or should, if you have some other sort of claim over it, you should be able to express a voice in respect of it?
That's interesting in the context of this statue, because the merchant venturers who paid for the statue to be put up were given a say in the future of the statue by Bristol Council, even though it was in public land. So here Bristol Council felt that all what might be described as stakeholders should have a say, but that's something that the protesters have objected to. Any thoughts on that? What's that one? So what can you see there, Ed? I've lost.
Well, there's a question here for you, Helen. So, will the removal of the statue destroy the property?
That's a very good question, and there's that question was raised in the Banksy case, where the removal of the painting from the side of the property. Well, yes, I think let's work on the basis that it wouldn't destroy the property. And I think somebody a very long time ago now talked about whether an owner owns everything affixed to the land or not, and that's a question that law has to decide about chattels and fixtures and fittings,
and what it means for things to be fixed to the land. Yeah,
what it means for things to be fixed to the land. Quite.
And there's a very good point, that it may change the value of the property, and value obviously is a critical part of the sorts of things that we need to think about, because property isn't something that just exists outside of value and money being attached to it. Many cases will be brought around questions of value, and they will be central to those sorts of issues.
And that also takes us something we didn't anticipate talking about, Ed, but is really important if we're going to take value away from a property owner. That takes us to human rights and Article 1, Protocol 1, which you'll learn about when you study law, which is that you have a right to keep your property, and if the state takes away your property, it has to compensate you for it. So I think the sort of questions that are emerging from the discussion here are really important and significant questions, and they're ones that law has to constantly debate and revisit. So Article 1, Protocol 1, which was a right that was brought in to protect communities like the Jewish people in Germany who lost their properties, are brought in to protect that, then can be used to defend perhaps people who we don't feel so sympathetic with keeping their property. So interesting. So that covers one thing that both Ed and I are very interested in, which is rents, private rents. Why can't they be frozen, or why can't all arrears of private rents that have arisen during the COVID period be just scrapped, got rid of? Well, that's because the government can't take away the right to property of private landlords. So really interesting and profoundly important points that you're bringing up here about property ownership.
Absolutely, I couldn't agree more. And I mean, the other thing that it brought to mind was the question of value in relation to leasehold properties, which have got Grenfell style or other types of cladding attached to them, which are questions are being raised about whether that those properties are unsafe because of the adequacy of the regulations which were in place. And so whether the value of those homes has been impacted by the approach by the state in relation to the rules around building houses. Helen and I have done some work thinking about this, and Helen sits as a judge, as she said, on in the tribunal that looks at some of the questions about leasehold properties in relation to some of those sorts of questions of value. And law has a role to play in working out who gets, who is entitled to support and who isn't, and who has to pay and who doesn't. I mean, we've moved away from this actually, but these are critical questions that are vital parts of property law and of land law.
Yeah. So land law will allocate rights and responsibilities between different people, and one of the things we become concerned about is who gets the rights and who gets the responsibilities, because it's a bit tough if you're a leaseholder. Flat will be made worthless because your cladding is flammable if you end up with the entire responsibility for replacing that cladding, and the person who owns the freeholder has no responsibility at all. Very good question here.
Very good question.
What is a leaseholder? Very good question. A leaseholder is somebody who owns a flat in a block, perhaps a tower block. So they bought that in the same way as you might buy a house, but because, so say in London, that flat might cost you £500,000, but you don't get to own it in the same way as you would if you owned a freehold house. You only get what's called a lease in it, which lasts, say, for 99 years or 150 years. So, and then there will be somebody else who owns the ground that this block of flats or tower block is built on, and will also own the common parts. So that's how English law splits out those two things. Like, well, somebody said, is it like Grenfell Tower? Do you want to answer that, Ed?
Yeah, I mean, so the important thing about blocks of flats is in many blocks of flats you can have people who are leaseholders who own the flat for maybe the flat has been bought for 150 years basically, or 99 years, and then people who are renting the flat on a shorter rent, and they are known as tenants. Many of the people in Grenfell Tower were tenants, and so were renting the property, some from the local authority, many from we don't need to get into all of the complexities of it, but renting it from effectively from the local authority, and others had a lease, so they were leaseholders in relation to some of those flats. So I think the thing that I think is that I wanted to say about this particular point is that Helen said that you might end up as a leaseholder having to pay for the removal of the cladding, or for dealing with the problems in the flat. And we went to a conference where somebody who was talking about this experience and saying it felt like a merry-go-round, and then it stops, and then whoever's left in the flat at the point where the something needed to be done about the fire safety, had to pick up the bill. So it wasn't the fault of the developer to pay, it wasn't the fault of the owner to pay, it was the leaseholder who bought the flat without knowing that there was damage, that there was a problem with the flat, not damage, that there was an issue with the flat. And it comes to this next question, which is this question of, so how properties...
Actually, we've just had some sort of good questions that we've actually got time to answer that we might not thought we did. So someone asked, can you actually buy a flat? Yes, you can, but this goes back to our sort of relativity of title. You can buy a leasehold of the flat. So it's a form of ownership, but it isn't as powerful a form, perhaps, to say as ownership of a freehold. So somebody else said that somebody asked the question, if you own the leasehold, is that as powerful as if you owned a freehold? And actually, the person who owns the freehold is the person who's in the strongest power, because a freehold lasts forever, whereas a leasehold interest is time limited. And from the minute you buy the flat, the time length of your flat starts to decrease. And you have to buy the flat on a lease where the contractual terms of that lease are decided by the freeholder. So I think that picked up most of the questions that we were asked there. So, okay.
Somebody said...
Oh, yes, that's right. Somebody said that as well. When the leaseholder dies, the leaseholder, when they die, they can leave their interest. So we've talked about interest, whatever remains of the length of the lease, to their family, to their children. Yeah. And also there are statutory rights where if you're a leaseholder, you have the right to buy more years of the lease from your freeholder. But we will look at that all in year 2 of land law if you come to Kent.
But Helen, yes. I wanted you to pick up on one really great point there, which is no one lasts for 150 years, so why aren't they as powerful?
That's a really good question, because the freeholder will also leave their interests by will. Quite often the freeholder will be a company, and a company lives forever until it's wound up. And so you've got the freeholders who are forever. So even if your lease, well, there are leases that are for 999 years, but you're still not as powerful as somebody that has something forever. Does that make sense? Well, it is only in England and I believe New Zealand where there are leaseholds. It's a slightly it dates from our old feudal development of land law, so it's not intuitive or particularly sensible.
But what it does reveal is that these are choices that have been made about the way in which land is held, and that there are historical reasons for these choices, which it's important to uncover and try and unpick, to try and understand how we got to the place that we're in, and to try and to understand how things developed is really critical. Not to see these things in the natural order, that this is just how things are, and that it's the kind of the way of the world, but rather that there's politics that underlies these sorts of issues.
Somebody asked a brilliant question. Clearly a natural lawyer said, so if a company can own a leasehold, what happens if the company goes bankrupt? Well, law, of course, let's always remember this, law cannot bear a vacuum, so it will always come up with an answer. And the answer is, if you go bankrupt, there's a trustee, and the trustee takes all of your assets and then will sell them to distribute the money to the people you owe money to. So, and the company would be a legal person in that sense. So that's how this would work. What is a trustee? You see, this is a trustee is somebody who owns property for the benefit of other people. So in the context of bankruptcy, the trustee there holds the title to the property, but the value of it, they're holding it on behalf of all the debtors of the company. But
And,
don't do this until the final year of your degree. So we're shooting ahead of ourselves here.
But it's this really important idea that that again, it's a historical development, that trusteeship is a way that you hold things for other people, and you can't take the benefit of it. But then there's this huge complex, actually it's complex because it's, you know, you'll unpick it in the course of your study, but it's this area of law that has developed to allow people to hold property in different kinds of ways and to do different kinds of things with that property. We're getting some quite specific questions about mergers and companies and
not company lawyers, are we, Ed? We'll try and organise you a session on company law if that's what people would like.
So but I wanted to come to this question of this, the new owner, whether a new owner should be able. We've moved slightly away from the statute, but I still think that this is an important sort of question of whether we think the new buyer of this house with the statue in it ought to be able to pull it down without getting permission from anybody else. What do we think? Is that something that it would be? You know, again, these are property law questions. Be interested in any thoughts or questions. Well, your thoughts in relation to that. So, a person buys and so we've got someone saying they should ask for permission. Someone saying yes, if everything is fixed to the land. It's their property; they can do whatever they want with it. Questions about planning permission, heritage protection, absolutely, yeah.
There is something interesting to say about heritage protection in the context of this statute. So this statute was listed, which is how we protect property of historical significance in this country. But really, the law on listing is designed to protect buildings and isn't a very appropriate fit to statues. And so it is actually a criminal offence to destroy a listed property. So there isn't simply the criminal offence of criminal damage here, there's also the criminal offence of destroying listed property. But again, I think that what that shows is how anachronistic listed building law is when it's applied to statues, because surely, unlike a building, we're all entitled to change our mind about whether somebody should be celebrated by society or not. Somebody just said, somebody asked me a question and then it disappeared, so I've lost it. So you can list a statue. I think that's what they were saying. And the reason why it was listed is it's supposed to be a fine piece of sculpture.
And there's a blog on this question of listing in the materials at the end, which we can direct you to by a professor at Bristol. And some really interesting questions coming through. Why buy and sell listed property? Again, it comes back to this question of value, that there may be great value in listed property because it has market value, because people want to live in places that are beautiful, that have you know, the kind of cachet of living there. But it does come with additional restrictions. So ownership is not absolute in the way that it might sometimes be portrayed. So Helen, a question for you. Would it make a difference if the house was leasehold or freehold?
Well, that's a really good question. It would depend if the freeholder had kept control of the garden or not. So you would have to read the terms of the lease, so that it would be whether the leaseholder, but also there could be terms in the lease, even if the leaseholder had control of the garden, there would probably be something saying you can't take the statue down without the permission of the freeholder. So there we'd go back to read the terms of the lease. But I think the thing you just said there, Ed, about you can't, even if you own a freehold property, you don't have absolute control of it. There are laws like planning permission, as people mentioned earlier, like listed building, other rights that will affect your control of the building. So you have far more control as a freeholder than you do as a leaseholder, but you're unlikely to have absolute control. And that's something that you also think about in foundations of property. But even if, you know, if knotweed is growing in your garden, the state can intervene, even if it's in your back garden, to tell you you've got to get rid of it, and if you don't, it's a criminal offence. So there are lots of things that stop you having absolute ownership of property.
And I have to say, we're getting some great questions through, and we can't necessarily deal with, well, we can't deal with all of them, but there's been some really fascinating insights and reflections coming through on the chat.
What about the one, what if you can't afford to get rid of it? That is a brilliant question. If you're a property owner, the state thinks you can afford to properly maintain your property. So what you might have to do is put a charge on your property, get an extra mortgage in order for you to deal with your broader obligations as a property owner. Capitalism, somebody has said. There you go. Capitalism.
Absolutely. Yeah. So I mean, yeah. What's an extra mortgage? Someone has asked. Well, if you buy land, you can take a mortgage out on it, which basically means that the bank or whoever else takes the mortgage has a charge over the property, which means that they have rights in relation to the property. And if you don't continue to pay them for that in relation to that charge, then they can take action in relation to the property. So yeah, absolutely, you have to put yourself into further debt. The next question, yeah. And that goes back to those people who are living in properties which may have lost their value because of flammable cladding on the outside or other fire issues, but who are being asked to pay for the costs of remediating those buildings.
And of course that's problematic because the cladding is flammable. It means your flat is worth nothing. So no lender is going to lend you the money so that you can pay to replace the flat, so the cladding. So you're absolutely caught in a catch-22. Your flat has become worthless and you can't sort it out because nobody will lend you the money to because your flat is valueless, to put the situation right.
Absolutely. Sorry if there's a small child running around the background. I'm sorry if his squealing is making a bit of noise, but yeah, apologise for that. So, I mean,
another very good question, which Ed and I have actually researched on, which is about the risks to tenant safety from the cladding on Grenfell Tower. And yes, the answer to your question, which is, doesn't it have implications? Yes, it definitely does. And there, environmental health departments should have taken a more proactive approach to control the quality of what was being put on the building, because by failing to control that, they not only put people's lives at risk, but people lost their lives.
And someone else has commented, it will get back its worth when new insulation has been put on. Well, potentially, but it might be that the works required are so significant that it may not be possible to remediate, or it might not be possible to to borrow the money to be able to get the work done. So the state has created schemes to assist people, but there's lots of concern by leaseholders and others that there aren't enough funds in those schemes to be able to assist everyone.
And if you're in a tower block and perhaps you can raise the money but everybody else can't, that's a disaster, because you're all dependent upon each other, aren't you? And I can tell you, this I do know from my judging, putting scaffolding up for a tower block is question of spending millions of pounds. So you have to spend millions of pounds before you can even start putting problems right. I missed that last. I think there was an interesting question just came up.
There's a lot. They're all interesting.
They are all interesting.
We haven't been able to pick up.
When you're designing your foundations of property course, you could take some of these into account.
Yeah, I will.
Well, yes, that's. I think the whole inquiry is considering. It's taking the inquiry several years to decide that question of responsibility. So we're not going to come to a quick decision here, are we, Ed?
No, it's an enormously complex question, and really, what we would hope that you would be trying to do is to try and understand how you could possibly start to understand how to answer that question. So much of being a law student is about getting your head around the ways in which questions can be answered, as much as the answers to questions. The answers to questions are often not as important as the ways of getting to answers, if that makes sense.
Yes, the question of getting compensation if you die in something like that is a slightly different question. That's a question of negligence and damages through there. A slightly different question from the property question, and that's why we're in the context of property law, we're really thinking about other tower blocks where people have bought their flats. So there's a different way in which law approaches those problems, whether it's a question of tort, which is responsibility for damages and loss, or property, which has its own set of discrete property law rules.
So maybe we should come to think about some of the key kinds of lessons that we wanted to come to in this discussion, and these are the ones that we've got up here on the slide. That as we've talked through some of these issues, and we weren't planning to go beyond the discussion of the statute, but it's been fascinating to have this wider conversation. That really the idea that land has a social function. And that ownership is not something that you can take for granted, but that it is something which is that is a social question, a social function. The politics underlies property law rules, and it's vital to try and uncover the politics in those rules, to try and think about those rules, and that land is fundamentally about relationships and not things or stuff. That land is about these questions of relationships between people. So to try and bring it back to the statute, the question of the statute, I think that you can say, sorry, there's a lot of screen in the background, that the statute demonstrates all of these different themes in different kinds of ways, that politics underlies these questions of politics, and the discussions and the points that you've made about responsibilities and these questions in relation to ownership are all demonstrated by that. So
I suppose what you're saying is that lots of people will have a stake in the future of that statute, and somehow we have to understand that the owner of the statue, which we think is Bristol Council, has to take all those stakes into account, but at the end of the day has to make a political decision about its responsibilities. Is that fair enough? Anyway, let's pull it back. We just need to start summing up. I think Ed and I have we've been amazed at the quality of this discussion. So thank you very much. We know that law and the way we think about property tends to emphasize control and rights. So the property owner can do whatever they want, and that tends to be the way we think about property. But what we've tried to get you to do today is to think about property, ownership of property, as something about responsibilities as well as about rights.
Yeah, and it's been a really fascinating a really fascinating conversation, and your contributions have been really, really engaging. I did have a final slide there which I just took down, but which I think we can make available, which had some additional links to some of the materials you might be interested in reading on the statue in particular, but also on the pandemic. There's been some interesting discussion amongst property scholars about property in the pandemic, which has been produced by global scholars who are interested in property and approaches to property. So we can try and make those available to you. Probably Twitter might be the easiest way, but we can think about making those materials available to you.
Yeah, and so what you've got anything to say about statues at the end of this? I think our point was really that owners of statues, of historical figures, have responsibility, moral responsibility, political responsibility, and some form of legal responsibility to think about their continuing existence in our public spaces. And I think we've all realised this in the course of this discussion, takes us right into politics. And we could have spent all day talking about the politics of property. We can't do that today, but these are key questions we examine in the law school. So those of you who are coming to us, you'll get lots of opportunities to talk about this. One of our central concerns at the law school is who wins and who loses, and who wins and who loses from property law, and a form of property law that emphasises control is something that we're very concerned about. But we're also concerned about the decolonisation of the curriculum, and looking at politics, and the way we've looked at it today, we would see as part of that effort.
So somebody asked for the links up there, and I've just put them on the screen so that you've got. I should say that the next webinar is about how to read law in cases, and is about cyberbullying. And so we hope that you'll, well, it will be fascinating. Hope that many of you are able to join us there. And as I say, we will make these links available. Those of you who've registered, I think we should be able to email these out to those of you. And if not, then I think we should be able to put them out on Twitter.
So, do we know when the date of the next webinar is, Ed?
I'm hoping that if we wait 1 second, we'll be able to be told when the next is. 2nd of July.
Okay, so I think it's time to wind up our hour, which has been fantastic. So thank you all very much for coming along. We've been really pleased to meet with you and listen to your comments and try and respond to some of them. And we look forward to meeting some of you, lots of you at Kent in the future. So it's goodbye from me.
And it's goodbye from me. All the best.
Thank you.